Hello, everyone. I'd like to welcome you to the first ever No State Project Adventures in Legal Land roleplay. And one thing I just want to do initially is go through what we're going to do here is roleplay scenarios in court and how to defend yourself best by bringing up the very pertinent issues in every case and asking if they exist or not. And before we even jump into anything, for anyone who has never been to court before and doesn't understand the role of all of the people in court and how your case is going to be litigated, which just means how they're going to legally process it, litigation, I want to go through and talk about each of the people who will be dealing with your case and what their roles are and what the responsibilities are. So, to start off, we have the judge, and he is one who's going to either convict you or throw your case out or find you not guilty. He's the most important person in your case. He basically determines the fate of whatever the dispute is, whether it be civil or criminal. And his responsibility is, he do have many very unique and specific responsibilities, but one of the main ones we're going to focus in on here is their responsibility to inform you of the nature and cause of the charges and proceedings being brought forward against you. And the reason why that's so relevant with maybe, let's say, a traffic ticket or a drug case is that you could go in there and you say, all right, well, I intend on pleading guilty, but with this plead guilty, you're entitled to that information that I just said, and so you can ask them. That sets the premises for you to ask them certain questions to be informed, and so from there you can go on and you ask questions on standing, corpus delicti, valid causes of action, and really verify the complaint. And all you're really doing in layman's terms is you're asking them to prove their allegations against you. They're making a claim saying that you did something, and you're basically asking them to prove it, which isn't too radical or extreme, considering they're the ones, making the accusation. So all you're simply doing are asking is them to defend their position. And I don't think that's contemptuous, and it's certainly within the bounds of the court's jurisdiction and what their responsibilities actually are. And that's the main point that I would like to stress about the judge right now. We may elaborate later on and get into some of the other obligations the judge has. But that's just enough for now. We don't need to go too in depth. There's the prosecutor now. The prosecutor is the individual it's the attorney, not individual. They're far from that. They're monsters who take any case that's handed to them by anyone in a shiny badge, and they feel that they have the pseudo virtue of hauling you into jail and putting you behind bars, or taking some of your money to provide a corrective solution to your heinous wrongdoing, even though in many of these cases there's no cause of action, there's no complaint, there's no case. Hell, sometimes there's not even an adversary in this so-called adversarial court system we have here in the United States. So they're the ones who are tasked with actually proving the allegations from the complaining party to the judge for the judge to make a decision on. And next you have the bailiff, and the bailiff is just there to really maintain order. If anyone gets too out of hand or anything like that, they'll handle them. And also they do paperwork sometimes by giving paperwork between different parties or handling evidence in the courtroom. Other than that, they really are just an observer more than anything and really don't play a major role in your case. But they're there. They have a gun and a badge, so be aware. Next, you may not have the jury, but in some cases you will be tried by jury if you make it that far, and it's just a group of individuals, of your neighbors, giving their opinion whether what you did was right or wrong. And oftentimes that could be skewed, and there could be many problems. But we're not going to get too in depth with them because, of course, most of the cases with the Adventures in Legal Land type of questions never get to a jury trial anyhow, so we won't focus on that too much today. The plaintiff is usually the officer in traffic cases or drug cases, and their role is that they are the ones filing the actual paperwork against you and saying that they caught you doing this, that, or the other thing. And so they are going to be there to be cross-examined, and whatever their allegations are are when they give you a citation, are given with under a penalty of perjury. So whatever they state, whatever law they claim that you're breaking, they actually have to be able to defend that. And if they can't, well, they just gave testimony under penalty of perjury. So their position in your case is going to be very pertinent, and their responsibilities is basically to answer all the questions under cross-examination you may have for them about the facts of your case. And then last but not least is the defendant. And the defendant is you. You're here because you have a ticket and you want to ask questions because you're not a lawyer and you don't understand the nature and cause of the charges and proceedings being brought forward against you. So you as a defendant, you're entitled to be informed of these and to go ahead and ask your questions. And that concludes most of the people that you'll run into in the courtroom. So with that being said, I'll hand it back over to Brian.
Okay, so we're going to get right into it. First case on the docket, Mr. X. Mr. X, please approach the bench.
Okay, now here we have Mr. X. Oh, I'm sorry, Brian.
That's okay.
Okay, all right, here I'll right from the top. All right, we got Mr. X here. It seems that he has filed a motion to dismiss. And I'm reading through here. I haven't had a chance to read on it, although you've had it filed here for a few days. I haven't had a chance to review it, and so we'll take this time right now to review your motion. And it looks like here that you're bringing up a few issues. One of them is subject matter jurisdiction, the other one standing, and the last one here, corpus delicti. Now, I'm reading what you have written down here, and I do see that you have some case law cited, and I'm not quite clear on exactly what your position is here. So what I'm going to do is I'm going to go through these one by one and ask you to clarify on each of these issues why you think that they apply or not apply in your case, and what I'll do is agree or disagree with those, and we'll do that with each of them, and after that we will either grant your motion to dismiss or I will deny it, and we'll go from there to see if, how you would like to plead or how you'd like to continue your litigation. So let's see, the first one here is subject matter jurisdiction, and I'm curious, how do you think this applies or does not apply in your case?
I just have a quick question on the side. Calvin, are you the judge or the prosecutor?
Right now, I'm just the judge. The prosecutor isn't going to be involved at this point.
Okay, perfect. Can you repeat the question?
Okay, well, right. You have here subject matter jurisdiction. You seem to think this is grounds to throw the complaint out because you're claiming that there's a lack of subject matter jurisdiction. I'm a little confused, and I'd like you to elaborate on that.
Yes, Your Honor. As you may or may not have read in the motion to dismiss, I included the rules and case law under the standard for motion to dismiss to guide the court in ruling on the motion. As you can also read, the accused, that's me, the defendant, contends that this court is without subject matter jurisdiction. Excuse me. And attacking subject matter jurisdiction is properly done through a motion to dismiss according to the practice book, which is, by the way, the Rules of Court in Connecticut, Section 41.8, which states the following defenses or objections, if capable of determination without trial or general issue, shall, if made prior to trial, be raised by motion to dismiss the information. Absence of jurisdiction of the court over the defendant or subject matter. Claim that the law defining the offense charged is unconstitutional or otherwise, and so forth and so on, Your Honor. I'm sure you can read the rest of that. As far as the subject matter is concerned, again, within the standard, a necessary element of subject matter jurisdiction is the standing of the plaintiff. The plaintiff has failed to state a claim as they suffered no injury, and have claimed to suffer no injury. There's no facts on the record that would be provable in a trial to prove standing. Also, you'll also notice in my motion, under subject matter jurisdiction, there is no admissible evidence that the alleged plaintiff will be able to bring in. All evidence is hearsay. The only evidence that the officers claim exists thus far is the testimony from myself to him at the alleged traffic stop. Time of questioning, I was not Mirandized under the Miranda rule. I had no idea of my rights at the time. The officer will be using that testimony as evidence and is therefore admissible as hearsay. Furthermore, sorry, I'm reading down my notes. The defendant.
Well, let me just stop you here. I think I've heard enough to formulate an idea of where you're going with this, and let me explain one thing about jurisdiction in your case here. Now, the violation is that you have not used a child safety harness when required by law. Is that correct?
Your Honor, are you attempting to prosecute the case right now?
No. All I'm here to do is to explain a little bit clearly to you as the defendant, and again, you're not a lawyer, the subject, the matter of jurisdiction here and how it may or may not be established. And so right. So what we have here is that the jurisdiction is established when the ordinance or statute is passed here, and the ordinance or statute is by law that if you don't have your child lawfully restrained in a seat, that with the passage of that ordinance through City Hall and through the legislature, jurisdiction is assumed and established with the passage of that law. So there, in your case here, there in fact is jurisdiction.
I see, Your Honor. If you look further down the motion, you'll see I addressed that. The Connecticut Supreme Court has said that if a party is found to lack standing, the court is without a subject matter jurisdiction. The court lacks discretion to consider the merits of a case over which it is without jurisdiction. Further, standing being one of the most important jurisdictional doctrines, standing represents jurisdictional requirement, which remains open to all review at all stages of litigation, and that's the NOW versus Scheidler case from the U.S. Supreme Court. Most importantly, relating to your what you just said, Your Honor, in order to have standing, the plaintiff must allege personal injury fairly traceable to the defendant's allegedly unlawful conduct, and it must be likely to be redressed by the requested relief. And that, of course, was the AiLL versus Wright case, 1984, from the United States Supreme Court. And further, the Supreme Court has said in Bender versus Williamsport that plaintiff's complaint must establish that he has a personal stake in the alleged dispute and that the alleged injury suffered is particularized as to him. To have standing, the plaintiff must have suffered a particularized injury, which means that the injury must affect the plaintiff in a personal and individual way. The Supreme Court has held these not overturned for years, and it seems to me that the plaintiff in this case has failed to actually establish that he has any standing based on a personal particularized injury.
Okay, well, there are some things that there is some truth in what you said there. That standing is a jurisdictional requirement, and of course it has to be traceable. But what we have here is a quasi civil case, and with these certain, it doesn't have to meet all the requirements of standing. There are some things with statutes and ordinances where which makes it quasi, to where these things are just passed without necessarily having to fulfill that on a factual basis, as much more as it is just assumed when you unlawfully behave. And in this case, it happened to be with child restraint. So I think that the standing in this case is, like I mentioned earlier, constituted with the passage of the law. And I think that this and the thing is, with the evidence, that the complaining party here, the state of Connecticut, is filed a valid complaint against you, and that the facts and the evidence that you speak of, that of course have to be there, is that you violated the statute, and the statute again here is that you unlawfully restrained your child in the car, and the facts are is that the officer pulled you over, and when he looked at the scene, he observed that crime was actually happening, and so what he did is he decided to give you a ticket, and you decided to respond with your motion here. Now, the issues you're bringing up again have been constituted when the law was passed itself. So on the issue, yes.
Excuse me, Your Honor. I'd like to enter forward on the record an objection further. In addition to my objections raised in the motion to dismiss, you had claimed earlier this is a quasi civil matter, quasi criminal matter, or something of that nature. I invoke Miranda versus Arizona, the United States Supreme Court, which held that there may be no rulemaking or legislation that would abrogate any secured rights in the Constitution. One of my constitutionally secured rights is to a common law trial on criminal matters. You're telling me this is quasi, which means it's a court of equity. I object to the equitable proceedings and demand common law proceedings henceforth.
Well, I'm going to deny that because that might be a case law, but that case law, from what I understand, is from Arizona. And now here in Connecticut, each state has its own set of laws of how they deal with cases, and that is not Connecticut, so I cannot grant or sustain your objection.
Your Honor, do you understand that Miranda versus Arizona is a United States Supreme Court case from 1969, and you are bound by the law of that case?
Okay, and do you have this case law with you here?
I do, Your Honor. I have a copy of it right here. I'll hand it to you.
Let me review it.
You'll see right down, Your Honor, I have it highlighted about halfway down the page in the opinion where it says, quote, where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Again, that's from the Miranda versus Arizona Supreme Court case from 1969.
Well, I don't think I'm violating constitutional law here. So again, I think I'm compelled to deny this. I'm going to have to disagree with you. And again, sir, I'm going to have to, Mr. X, I'm going to have to advise you that if you want to continue down this path of questioning, that this is quite contemptuous. And if you don't understand these proceedings here, I would advise you to get a lawyer.
Your Honor, I of course will concede, except for on the record, I want to take exception to what you just said. Let's do proceed. And also for your information, I am not a lawyer. I do not have a lawyer. Do not wish for a lawyer. Cannot afford a lawyer. And do wish to understand the nature and cause of the proceedings here today.
Okay, and I think we are moving forward in that. However, I don't think I've heard a defensible position for your motion here now. So if you have nothing more to add, I do see that there was corpus delicti on here. Now, I do just want to preface, I remember from law school that corpus delicti is a standard on the criminal side. Now, with your violation here, this is quasi-civil. So in your case, your corpus delicti would not apply. So what I'm going to do is I'm going to, I think we've, I'm sorry?
Objection, Your Honor. If I would please, for on the record, object. You are correct in that corpus delicti applies typically to criminal matters. However, as earlier pointed out in the case of Raines versus Byrd, Bender versus Williamport School District, both Supreme Court cases, and of course the Connecticut Supreme Court case, Missionary Society Board of Pardons and Paroles versus Board of Pardons and Paroles. In those cases, it sets a civil standard for claiming standing in regard to injury, and I'll be happy to quote it again if you'd like. If not, we'll go ahead and check the record later. However, those were indicative of civil matters. So in the civil matters, my defense, of course, is that there is no standing based on a lack of injury claimed by the plaintiff. And in criminal matters, as you notice, I have a defensible position around lack of corpus delicti. There is no corpus delicti in this matter, and therefore the case must be dismissed.
Okay, well, I've heard your position and your arguments here, and I think while the are very well versed. I don't think they're completely sound, and as I said before, I think we've gone over subject matter jurisdiction and standing. I just don't think that the whole legal weight. And again, I understand you're not a lawyer, so if you wish to pursue these issues, you are welcome to get a lawyer. Now, you did mention that you cannot afford one. However, one can be provided to you in the case that you cannot. So the court can provide you with a public defender if you would like to pursue this case. And it sounds like by the line of questioning you're taking here that you told me when these proceedings first started that you intended on pleading guilty, but you had some questions. And I think what we've got here is that you do not intend on pleading guilty. You're challenging the court here, and you're being a bit badgering with your questions. And I think we've talked about these. So what I'm going to go ahead and do is we've gone through these issues. I don't think it's a legally sound motion, so I'm going to go ahead and deny your motion, dismiss. And at this point, I would like to ask, do you intend on pleading guilty? It sounds like you are barking up the not guilty tree, but I want to ask for a plea or whether you would like a trial.
Okay, Your Honor. I apologize for being seeming combative or anything like that. I'm just trying to get to the bottom of the matter here and, of course, protect my rights. Now, first, I'd like to object and take exception to your ruling of denial, just for the record. Also, prior to that, you mentioned that I had a plea of guilty or had an intention of pleading guilty. If you look in the case file, Your Honor, you'll notice I actually had entered a plea of not guilty by the time assigned on the ticket. And I did so in writing expressly under duress because on the back of the ticket, as you may notice, I have a copy thereof in the file. It had threatened arrest and other things to be done to my person and my property if I didn't comply with either pleading guilty or not guilty on the back of the ticket within 9 days of receiving the ticket. Therefore, the plea, I'm not sure is even considered a plea because I did not enter it willfully and on my own accord. I was entering it under duress. Now, that being said, I further sent a letter to the prosecuting authority a few days after sending that plea in, requesting, per the rules of court, Connecticut Practice Book, Section 41.
Okay, Mr. X, hold on. I think I've let you go on long enough here. We've already gone over. I've noted your objections here, but you did point out a very pertinent fact that you did plead not guilty. And so I think the next plan for action here is we've heard your motion here. I've already denied it. So what we'll do is we'll set this for trial. You intend on pleading not guilty, and we will allow you to ask. I think these questions and these are questions better suited for trial. So what we'll go ahead and do is we'll set this for trial, and you come back at a later date.
Excuse me, Your Honor. I'm terribly sorry to interrupt. I really don't mean any disrespect, but there are a couple of issues which we're having a problem with here, I think. One is I do have a right to due process, and one thing is happening here. Part of due process, of course, is my ability to make my record. All of the issues regarding the motion to dismiss have not been heard. In fact, there's one pending right now, which I just discussed. As I was saying, I sent in a request for information, which is essentially a motion for a more definite statement regarding the nature and cause of the charges, and also to elaborate on the factual allegations therein. I received nothing back from the prosecuting attorney from the court or anywhere else I sent it to. Copies are in your file, Your Honor.
Okay, well, I'll tell you what we can do. I would normally set this for trial, and in between the time from now to then, you could discuss these things and get that information from the prosecutor. But what I will do is grant you continuance and allow you to go inquire to the prosecutor with your questions as you're telling me here, and we can go from there.
Your Honor, no continuance has been requested. May we move forward?
Well, the prosecutor isn't able to go through these particular facts right now. So what you'll have to do is you'll have to.
If he's not prepared for the case, Your Honor, excuse me. If he's not prepared for the case today, I move to dismiss. I come out of work.
Well, we are here in arraignment, and we're here not to discuss the facts. That's what this trial's for. And now it does seem that you want to discuss the facts in this trial, and that's exactly what it's for. So again, it seems to me that you are wanting you're asking to go through trial to get these facts on the table and see if they exist, but the discovery process here is something that you'll have to do outside the court with the prosecutor to get discovery, and you'll have to schedule a discovery hearing with him, and that cannot be done today. Today is just an arraignment or a hearing to hear your motion, and I've already gone through your motion and denied it, and from here it's just we're either assuming you're going to plead not guilty, like you stated on the citation before, and also before you filed your motion, we heard the motion, or you can plead guilty and you go ahead and if you don't have the time and you don't have the extra expenses that it may cost you to pursue this, then you can go ahead and plead guilty, and the court may or may not be more lenient on the fines assessed.
What is the order of the court, Your Honor?
Well, the order of the court is we need to know if you want to plead not guilty and set this for trial, whether you would prefer a continuance to obtain discovery and set a discovery hearing, or if you would like to plead 3 not guilty and pay potentially lesser fines now and save yourself some time and money.
Your Honor, has the court made a determination on the motion?
Yes, the court has determined that it is not legally sound, and it will not grant the motion to dismiss.
All right, Your Honor, I would like an evidentiary hearing, please.
Okay, well then what we will do is we will set this for evidentiary hearing. Okay, and I'll go and stop now. That would be the end of that hearing right there, and I know Mr. X that probably didn't make much sense at all, but I have to tell you that everything that I've just those arguments, those heinous arguments that I've given you are arguments I've actually gotten in court, and some of which I have recording of. So I know it may seem that I've had one too many today, but I've heard those all verbatim, and in fact I was actually more gracious than some judges might be. A lot of times they'll stop the questioning, and if you continue on even with an objection, they'll consider that contemptuous and want to go forward from there. So I guess where we could pick up is you want to have an evidentiary hearing, and this is going to be, I got to admit, this is going to be a little off the cuff here, and it may be quite unprofessional because I've never done a discovery hearing myself, so I can only go by what I assume would be discussed by the prosecutor. The prosecutor is going to basically make an argument, and you're going to have your disagreements with your questions. The prosecutor is ultimately not going to be responsive to what you're asking. He's going to cite law instead of give you facts on what you're wanting discovery on. You want discovery of particular specific pieces of evidence to substantiate their case. And since he's not going to be able to provide it, he's going to most likely cite law and say that he gave you a discovery hearing. And so I think we may just leave it at that simple explanation right there and then just go straight to trial because again, I don't have the experience, and this is something maybe Mark would be better to have here at with discovery procedures, just because I haven't. So what we'll do is we'll go and continue right now and just assume that discovery's been had, or it's assumed to have been had. The hearing's done and over with. You didn't get the responsive answers you wanted to your question, but nonetheless, the next thing will be a trial here. So you'll find yourself in trial. So does that sound good, Mr. X?
It sounds great. Would you mind if I just answer this question? I think one of the listeners has put it on, says, why would anyone want common law over equity? I have the answer to that.
Go ahead.
Does he still want the answer?
I would just go ahead and put on. It's been brought up. It's on record. So any of the listeners downloading, we don't want to leave them hanging. So just go and answer, and we Brian and I could chime in.
Yeah, definitely give the answer because people are listening and it's being recorded. Okay.
Well, I don't know how much anybody knows about the history of Anglo-Saxon law, which is our tradition in America, but the two kinds of law systems, two kinds of courts. And they did both exist even in America up until about the early 1900s. Common law is law. Like when the Constitution says the judicial power shall extend to all cases in law, that means common law. That is the law. Equity is something. It means fairness in Latin, and what it really means is that the judge gets to or the judge as representative of the sovereignty, which in the United States, they claim anyway the sovereignty rests in the people, but they basically run it as if the government is sovereign. But anyway, the judge in an equity proceeding has the power of what's called chancellor, which is representative for the king. So he basically can decide whatever he wants. Now, in this country, obviously, we have constitutional limitations, supposedly, on what judges can do. But as Mark Stevens points out a number of times, we have things like the necessary and proper clause. We have other things in the Constitution that get distorted and abused so that they have discretion. The biggest problem in any court is the discretion of the judge. There's absolutely no question about that. Now, the difference, of course, is that in equity, the judge, by the nature of the court, has that discretion. In fact, the very nature of equity itself is that you're asking, both parties are effectively consenting and asking to the king or the chancellor to decide fairly on the matter. Hey, we got this discussion here. We have a dispute. Can you decide it for us because we're incompetent apparently to decide it ourselves? Now, the thing about equity is that it follows law. That's actually a maxim of equity. That means that law, and the reason why law is listed first in the Constitution is because law, or common law, is superior. It's superior law because it is the law of the people. It's also, the king has a common law too, but we have it here too. It's called stare decisis. It's case law. In the United States, the king's common law is case law. The people's common law is jury decisions. But anyway, so if you are in an equity proceeding, and by the way, there are a lot of mixed proceedings. Like I said, they combined both court systems back in the early part of last century, and now most courts, not everywhere, but most courts in most states they handle both equitable matters and legal matters. Legal matters means common law matters, but again, equity follows law. So if the whole point of common law really is to determine the rights of the parties. It's all about property. It's all about rights, and rights are property. So, if let's just say there's a contract dispute, which is contract law is based in common law. Contract law is right out of common law. When you have a contract dispute, you go to a court of law. The court of law makes a judgment determining who has what rights, depending on what the contract is determined to be. And then let's just say, for example, the parties aren't happy with that decision. They can then take that decision and all the facts surrounding it and go to the equity court and say, hey, we got the decision at law, so we know generally what the rights might be, but it's really not fair, so we need you to kind of alter the arrangement and be more fair about it. And that's basically the underlying principle. So whenever you're dealing with equity, you're dealing with the discretion of the judge generally. So, and that's why criminal matters typically take place at law. Also, it's because of the Constitution. It's true you can have civil matters. Well, I shouldn't say that. It's true you can have, I'll say civil matters because everybody knows what that means, but you can have private parties suing each other at common law. You can do it at equity. You can do it at both, depending on the state, depending on what your laws say there. But generally speaking, the common law is superior, and it's a little more strict. The reason why equity even developed is because common law is just extremely strict in terms of procedure and the law itself substantively. Yeah, I'm going to stop talking now. By the way, I got to say goodnight to my kids. I'll be back on in a few minutes to continue with the role playing. Do you guys?
No problem, Mr. X, and thanks for that explanation. And while you're away, I'm just going to go ahead and basically summarize what you said and kind of put it into my own words, because that's new terminology, or somewhat new terminology for me. I'm not really familiar with equity law, but from what you've described, it seems that equity law kind of seems to be this quasi-crap that you get in the courtroom when the judge wants to say, well, this is a quasi-civil proceeding or a quasi-criminal proceeding, and where it's more at the discretion of the judge to really reinterpret, misinterpret, or basically interpret the law on their own subjective basis, whereas common law seems to be a bit more objective and it has to be substantiated factually, and it's more from a negative position where it has to be proven. And so whereas this equity law is just something that can be morphed and manipulated at the hands of the bureaucrats. So that seems to, and I'm not sure if you're still with us. Are you, Mr. X? No. Okay. Well, that
yeah,
seems to be
sorry,
my take.
Yeah.
Oh, okay.
Do
you agree? Did I get that right, or?
You're pretty close. What happens is that you have, and by the way, just to make this clear, no matter what anybody says, almost all proceedings in the United States these days follow equity.
Oh yeah, it shows.
What they do is they actually the arraignment process itself is your waiver of law. In other words, you, how should I put this? As an American, you have a right to be heard at the common law, which is really, again, it's strict. It's pretty tough. I mean, the common law is serious business. I mean, that's, it's if you get caught doing something unlawful, like burglarizing or something like that, assault, or there's some pretty serious. I mean, juries have done some serious things to people for those kind of crimes. Whereas statutory law, isn't so bad. First offense isn't so bad, and then maybe we'll have to do some jail time later. It's a little nicer to criminals. But anyway, the idea that you were talking about, the judge's own discretion, what they say, their public policy says that they have to, they have to have an order of things. In other words, they look at it in the light of the law, and then if that doesn't work out for some reason, then they look at it in light of equity. And if that doesn't work out, or there's not enough matter there to determine the equity, then they go down to public policy, whatever they basically feel is good for the public. And, one example would be like foreclosure proceedings. If anybody's fighting foreclosure, I'll tell you what's going to happen. Foreclosure actions typically are a mixture of law and equity. You need law to determine the contract, and you need equity. Foreclosure itself is an equitable function. It's actually an equitable thing. Anytime the court orders you to do something, that's an equity function. Like the court says, there's an injunction against you from doing this, that's equitable. That's an equity function.
So you could have judgment of common law without it being an equitable manner, but you cannot have a judgment on an equitable manner without common law being involved. It first goes through that hierarchical process. Do I understand that?
Yeah, supposedly. And I've seen it in action. What they do, back to the arraignment. The arraignment process might actually help clear this up. What the arraignment process is, why does arraignment exist? Because it didn't used to. It kind of came about earlier on. I mean, yeah, there's sometimes there has to be a probable cause hearing, but that kind of got combined into the arraignment process for big criminal felonies and things like that. But then there were also other things mixed in. But generally, the modern arraignment is sort of it's a way to secure your consent to leave the land of the law and go right into equity. And what you're basically saying is when they say, do you plead guilty, not guilty, or no contest, if you notice, it's always on some sort of statutory charge. Like you violated the section, you violated Title 14, Section 6321 -2, right? That's a statutory provision. Now, of course, there's a similar crime at common law. Let's just say, for example, name something. You stole a car, theft, right? So there's a statute that says, if you steal a car, I'll make it short. If you steal a car, then you are subject to the penal code for that particular offense, and that might be 3 days in jail. Okay. Now, obviously, the statute was created, let's say, 100 years ago. But before 100 years ago, was there a crime for theft of motor vehicles? Of course there was. But it was at common law. It was just understood to be the law, and juries would convict you on that, and that's basically common law. But you were subject to the jury decision on that, so which usually was a little more harsh than the statutes kind of thing. Now, the statutes, what they confer is a benefit. In other words, what you're saying is, one of the secured rights of the people in the Constitution, which is unwritten. Well, actually, it is hinted to in a number of places, and in government writings themselves, you can find the government will tell you that the common law, actually the courts will tell you that the common law is gone, in terms of being enforceable in the courts.
Well, especially for these traffic violations and the violations where they make most of their money off of. Because they'll invoke it when it benefits them, when they're sued for wiretapping and this and that. They'll use common law, all day. In fact, throughout the ACLU case against the federal government for wiretapping on the grounds of standing, which to me sounds more up the leg of common law than it does equity law.
Oh yeah, there's a number of things there. That's a whole show right there. But the what was I getting at with the statutes? What you're doing in effect is at the arraignment, you're saying, I know that I have the right to be tried at common law. That doesn't necessarily mean a common law court. I mean, I don't want to get mixed up with all these different movements with all kinds of common law stuff. But the idea is, there are courts that proceed according to the common law, which is what they're supposed to be doing actually. And nothing wrong with that. It's pretty simple. That's the way it's done. But anyway, what you're doing at arraignment effectively is saying, you know what? I'd rather not be tried at the law, and I'd rather accept the benefit of these new statutes they've made that kind of make it easier for me to get off. You know what I mean? Or whatever, for whatever reason, it doesn't matter. You may not even know about your common law right. You just may see that you're being charged with a statute and plead not guilty, or whatever, no contest. Once you enter a plea, that's a factual question. Once answering a plea is you're engaging in discussing the facts. I don't know if you guys know anything about how courts work traditionally, but the whole idea of a court is to settle two issues, and issues of law and issues of fact. The reason why Mark likes to do a motion to dismiss first is because motions to dismiss deal with the law, which is something that you want to deal with first, because even though Mark typically goes on facts and destroys cases based on lack of facts, what Mark is really doing is challenging the jurisdiction, which is a legal question. That's a law question. Because, facts are things like, Billy took Steve's car. That's a fact, and there's a witness. But did Billy steal Steve's car? So the word steal then becomes a legal issue, because you're applying an opinion to it.
I got to say though, I think Mark's motion to dismiss. You're saying it's more of a questions of legality, but I think I'd have to disagree, because my understanding of it is that when you file a motion to dismiss, even though it's a legal motion and it's going before a court, who decides things on a legal basis, what he's bringing up there is issue of fact on whether, not so much, do these things exist or not, but also, and more importantly, and it's not really spelled out in the motion, but is it applicable? And I think that's kind of what you're going to as well, is this law even applicable to me, let alone, let's throw out the issues of standing, corpus delicti, valid cause of action. What evidence do you have to show this is applicable? And this is something you should be able to do without filing a motion for, but I think that's how he uses that motion, as an opportunity between the arraignment and when you first get that ticket to bring up the applicability of these things. Although I do understand what you're saying, in that he really goes at these legal issues and asks if they exist, and so therefore engaging in the legal process.
Yeah, he likes to. It's true that Mark likes to avoid legal questions. I'm just saying that a motion to dismiss that attacks anything that attacks subject matter jurisdiction, standing, anything like that. That is a question. That's what's called a question of law, because what you're saying is, at least for that instance, in other words, you can find this kind of information in most case law regarding the standard for a motion to dismiss, and that is that and a motion to dismiss, by the way, is kind of a modern version of what's the old common law demur. Some states still have demurs. That's D-E-M-U-R-R-E-R, a demurrer. A demurrer, when you demur something, that means you object. And in the common law procedure, which is where the basis for all of our procedure these days, most of it anyway, what you're doing by a motion to dismiss replace the demur in most states, but it's the same idea. What you're doing is you're challenging jurisdiction, because jurisdiction is a question of law, because there's a certain set of facts. Is there a law that applies? Is there anything that basically says that this set of facts is wrong? The other side of the coin is motion to dismiss and also motion to strike can attack what's called the legal sufficiency of the complaint. In other words, just to give a more illustrative example, let's just say there's a statute and it says if someone has a blue car and is driving it on Tuesdays on Main Street, then they committed an offense against the public and should be fined $100. So what did I just say? Blue car, Tuesday, Main Street, right? So the factual circumstances set forth in the statute that constitute the offense would be driving a blue car on a Tuesday on Main Street, right? Now, if you get a complaint from an officer that says X was driving a blue car on Main Street, right? That's all the complaint says. Well, the proper way to attack that is a motion to dismiss, where you say the plaintiff has failed to state a claim upon which relief can be granted. And you further expand on that, saying the plaintiff has failed to state facts sufficient to constitute a cognizable claim or a claim cognizable by the court. And the court would have to agree with that, because all you do is put the statute right there. You say statute, whatever, Title 10, Section 4 says or states or provides, and you quote that, blue card Main Street Tuesday, or you don't have to. You can just refer to it with a citation and not put the actual text. But you're basically showing the court, look, the guy made a complaint. He didn't include all three facts, and therefore, none of this applies. So have a nice day. And that's pretty much the idea. I'm just trying to clarify that. I agree with what you're saying in substance. What Mark is really saying is there aren't facts here. There's no way. What Mark is really saying is there is no way that there are enough facts here to say that I did anything wrong. Nobody has an injury. Nobody's stating enough facts to constitute an injury. So yeah, it's I guess the right way to. I'm being, I guess, anal about terms. The reality is that
splitting hairs, as it's said.
Yeah, the motion to dismiss is a legal attack, but it really does talk about, I wouldn't say issues of fact, because an issue of fact means there's a disagreement. If somebody says that it was blue, someone says it was red, that's an issue of fact. But what you're really saying is that Mark talks about the fact that there aren't any facts or not enough facts to even constitute any sort of claim, and that's kind of the idea.
Okay, yeah, I think I understand that, and well put, and it'll be interesting. I don't know if you'll have time to join us next week to bring this in. Hopefully Mark can I'm sorry?
Oh, yeah.
Hopefully Mark can join us, and we could get him in on the action here and really put this to him, because I think these are going a little on the deep end of the pool of his material, and I think him being here to really respond to that probably the better way to go, because I do agree with you, though. Yeah, he is making a legal argument and saying that these facts don't exist legally, and so right, I can understand that. So I think the trial portion too of our call today, we'll hold that off for next week. I think the intention here is to keep these rather brief, because these are very rich in their technical content, and if we extend this to more than an hour, we run the risk of overloading maybe some new listeners' minds with a little too much information. So we want to keep it, at least at first, in smaller segments, so that we could really digest this information well and build upon it over time, rather than just condense it into 2 or 3 hours worth of listening. So I think right now I just want to say join us next week. We'll have it linked up on Mark's site. If you want to go to Talkshoe.com, search for No State, all one word, and the host of the show should pop up, and you should be able to click and find us there. And we usually kick this off immediately after the No State Project broadcast that ends at 6 p.m. Central Standard Time. And it may not be exactly right after, but that's when we're all getting together, and we'll start recording within a half hour after that, so rather shortly. And we invite anyone to come in and do some role-playing with us to better prepare themselves for court. And by collaborating, I think we really give each other the tools we need to help or to get favorable outcomes when challenging the facts in these so-called cases that these bureaucrats bring against us. So hopefully you guys all enjoyed it, and you guys will join us next time, next week.